she's arguing that the state basically says you're not allowed to provide the talk therapy, not any medication or anything, the talk therapy to change someone's feelings about their gender identity or their sexual orientation. And she says that infringes on her First Amendment rights, even as a professional.
Welcome to Deep Dive. As the Supreme Court kicks off its 2025 to 2026 term this week, we're diving into the high-stakes cases that could reshape everything from free speech and criminal rights to immigration and trade policy under the Trump administration. Joining me now is Jack Birle, the Supreme Court reporter for the Washington Examiner. Well, Jack, thank you so much for joining us.
Thanks for having me.
So your reporting gives us a front row seat to how the Supreme Court cases unfold. Let's start with the terms opener and build from there. We know that the tariffs are going to be a big hot topic. Is that correct?
That's correct. So the biggest case probably going into this term is this challenge, two challenges actually, they consolidated, of Trump's Liberation Day tariffs, as he's branded them. So that's the 10% tariffs globally, and then the higher reciprocal rates and subsequent ones. It also includes the ones that were the tariffs against Canada, Mexico, and China about fentanyl. Those tariffs, he used IEPA, which is a statute which has not been used to levy tariffs in the past, to levy these tariffs, saying he has this power. And some companies have sued, saying he doesn't have the power to tariff. Lower courts have said he doesn't have a power to tariff under the statute. The Supreme Court's now going to review it. That's set for the first week of November, and that's going to be probably one of the biggest cases out of the term so far. The term just started, but it's going to be a massive test of the Trump administration's signature economic agenda, and it could really have some sweeping effects in terms of foreign policy and economic policy. But the court, they just look at the law. So if the president can do it, then they'll say that he can. If they don't think he has that power, and that's how they rule. They don't rule about policy, they rule about the lawfulness of it.
And another hot topic seems to be transgenders in women's sports. I mean, we're hearing a lot about, violations of Title IX and some lawsuits being thrown out there. Is the Supreme Court going to be hearing any of these cases?
Yes. So the Supreme Court has agreed to hear two cases. They have not scheduled them yet, but they'll hear them sometime between now and April. So they're two separate cases. One is challenging a law in Idaho, one's challenging a law in West Virginia. They're pretty similar laws, pretty similar cases. These laws limit women's sports to biological women. So biological men who identify as women are not allowed to participate in women's sports under these laws. And the question presented to the court has to do with whether these laws violate the 14th Amendment or Title IX or the Equal Protections Clause. So this will be the first really major test for these laws at the Supreme Court. And last term in Sweatte versus United States, the Supreme Court handed a massive win to opponents of some of these transgender procedures and transgender policies. They said that Tennessee, and along with other states, are allowed to restrict these transgender procedures for minors. So that's kind of seen as that's how maybe the court is leaning on these issues. But of course, we'll have to see once we get to arguments, and of course, what the decision is. It's a little, it can be hazardous to look ahead and try to predict what the court's doing. But we think that these could be big wins for the states of Idaho, West Virginia, and the dozens of other states that have similar laws.
Interesting. And another one of your articles details how Birle versus Texas is one of the first cases to be looked at. So it centers on whether a Texas judge violated a defendant's Sixth Amendment rights by barring him from talking to his lawyer about testimony during an overnight recess. So walk us through the core dispute. Why do Birle's team see this as a slam dunk, while Texas and the DOJ argue it's just preventing coaching?
Yes. So the Sixth Amendment, not as talked about as much as the First or Second Amendment or the 14th Amendment. Sixth Amendment gives you right to counsel, right to a lawyer and to a trial. So you're entitled to speak with that lawyer and get advice from that lawyer. But of course, when you're testifying on the stand, you're not allowed to be coached by your lawyer. That's pretty standard procedure in trial courts. So in this trial court in Texas, Villarreal was on the stand testifying, and the court went into an overnight recess, but he was still on the stand when they went into recess and was going to be back on the stand when they resumed the next morning. And the judge put down an order basically saying, you're allowed to talk with your lawyer, but just don't talk about your testimony, because he wanted to avoid any sort of coaching. The trial ends, and Villarreal it was a murder trial. He was convicted of murder, sentenced to prison. In his appeals, he has said that his Sixth Amendment right was violated because of this order. The courts now reviewed it. It was the first case they had oral arguments on, and they seemed pretty skeptical of his lawyer's arguments that his Sixth Amendment rights were restricted. They seem it's hard. It's never wise to try to make predictions based on the oral arguments, at least definitively. But they definitely seemed skeptical of that, and they seemed more leading towards Texas's view that these orders can be like limited in scope to ensure that there's no coaching, but also still balance that Sixth Amendment right to counsel.
I see. And for viewers tuning in, this isn't a blockbuster like election cases, but you note that it has wide implications for multi-day trials. So based on your reporting, what should we be watching for in oral arguments to gauge the justices' views? For instance, if conservative justices like Thomas or Alito push back on Texas's discretion argument, does that signal a broader skepticism of lower court overreach?
So I think in this case, the justices actually did all seem, and this happens, there's a lot of talk about how the court is a 6-3 divide between conservatives and liberals. A lot of these cases, the justices have all sorts of different, like, nonpartisan divides. But a lot of times they're in agreement. It seemed like the court was on the same page, generally speaking, with kind of leading more towards Texas, because, of course, they understand that these rights, of course, are to be protected under the Constitution, but you have to balance that with these real life things like coaching and stuff. And so I think the court, in something that doesn't, I mean, you'll see some articles about it from time to time, but typically talk about how the court is so partisan and everything. But in a lot of ways, the court really does agree on a lot of issues, and a lot of decisions tend to be unanimous or near unanimous. And it looks, I mean, once again, not wise to predict based on the oral arguments, but they seem to be pretty much on the same page in this case, and that tends to be the case for a lot of these cases that don't make the headlines.
I see. And shifting to arguments in Chiles versus Salazar, your piece spotlights licensed counselor Kaylee Chiles challenging Colorado's ban on conversion therapy as First Amendment censorship. You interviewed ADF's Jonathan Scruggs, who calls it blatant censorship, limiting what therapists can say to kids with gender dysphoria. So, how did you balance that with Colorado's AG arguing that it's just regulating harmful health care? Tell us about your process. Did you reach out to Childs or state officials to get both sides on how this law blurs speech and conduct?
Yeah, so going into the arguments, I looked at briefs on both sides, talked to advocates on both sides, along with my colleague Kaylin, who helped out with one of the stories I wrote ahead of the oral arguments, which were on Tuesday. And really, it's a dispute between free speech, which is what Childs is arguing, and Colorado saying, well, we're regulating healthcare, we're regulating these gender conversion therapies, and it really comes down to that. And the justices during the oral arguments on Tuesday really kind of tried to see what was really the side that was prevailing. It seemed like they were skeptical of Colorado's view this as regulating healthcare, because Childs, what she's talking about is this is under a conversion therapy ban. And when people think of conversion therapy, they typically think of the archaic, barbaric, like shock therapy to try to shock people who are gay into not being gay and stuff like that. That's not what's at hand in this case. What Childs argues is that while it includes things like that, it also expands it out to where some of her clients who come to her and they're suffering from gender dysphoria, and they want to be reassured that they are in the right skin, like they are their biological sex. They don't want to change their gender identity away from their biological sex, but they're feeling conflicted and they want her advice and they seek her out. And she's arguing that the state basically says you're not allowed to provide the talk therapy, not any medication or anything, the talk therapy to change someone's feelings about their gender identity or their sexual orientation. And she says that infringes on her First Amendment rights, even as a professional. And that's really, it seemed like the court was more sympathetic. The majority of the court was more sympathetic to her argument in oral arguments than Colorado's. Of course, we'll see once the decision comes down. But it's a really interesting give and take between these two sides who really see the case in completely different lights.
Yeah, absolutely. And this is the term's first big free speech clash with, ripple effects on gender ideology cases later. So from your vantage, what oral argument cues might hint at justices' leanings, say if Sotomayor or Kagan grill on harm to kids versus Gorsuch probing government overreach? How could that foreshadow a win for choice in counseling? And is this the kind of case that could spark fiery hypotheticals from the bench?
So the court tends to try to be uh, not try to have these sweeping rulings that are very haphazard. They try to be generally as narrow as possible so they don't have all these issues down the line. And it can be sometimes it can be difficult to read how a justice is thinking. Sometimes you think you know how they're thinking, but then the decision comes out and they're totally on the other side. It seemed like the conservative justices were much more skeptical in their questioning of Colorado. So it seemed like they were more inclined to be on Childs' side. Elena Kagan, interestingly, one of the liberal justices, although sometimes she does side with the majority. Of course, you have conservative justices who sometimes are in the minority or will side more with the liberal justices. While it is a 6-3 split, it's not that easy. Elena Kagan, though, was definitely skeptical, it seemed, of Colorado's arguments today. Now, that's not necessarily a sign that she's going to side with Childs, but it certainly was something interesting. It did seem like all of them had at least a little bit of skepticism in Colorado, but Justices Jackson and Sotomayor definitely seem more skeptical towards Childs. Once again, not place any money on how the court is going to rule based on oral arguments, but sometimes you can get these hints on like how the justices are thinking, which side they're at least walking into arguments are more skeptical about. And then you get to see the results of their thinking, their questioning once the decision comes out. And we expect the decision to come out within the next couple months.
Okay. And now on to the Trump administration's wins on the shadow docket. So your reporting covers Friday's 6-3 order, letting them end TPS for over 300,000 Venezuelans, despite dissents from Sotomayor, Kagan, and Jackson, calling it a grave misuse. So how did you source the behind the scenes frustration like Jackson's plea for stability for families?
So a lot of this is, you can talk to court watchers and everything, but really what we rely on is what the court tells us. And on the emergency docket, which is normally pretty dull, there's normally not a lot going on. This summer it was fast and furious. There were lots of cases, a lot of Trump administration challenges from orders from lower courts, and the Trump administration was very successful in getting a lot of these stays, a lot of these lower court orders halted or paused or struck down. And in some cases, even some of the cases before they're even done in the lower courts have been brought up to the Supreme Court for arguments in this term. And so you really, these emergency orders tend to be very brief. They tend to not give a lot of opinion. When there are dissents, though, the liberal justices, especially Justice Jackson, Justice Sotomayor, very much like to have their opinion known and very much like to write why they think is a misuse. For example, the emergency docket, as they've said, that's been a repeated criticism from some of the liberal justices. And that's really the only way we get a vantage point into their thinking is when they give these orders. And on a television interview, Sotomayor was asked about one of her emergency order dissents. And instead of going into it, she said, it speaks for itself. Read it for yourself. She didn't delve into it. The justices, they all write opinions for the throughout the term for these cases they hear on the merits docket. On the emergency docket, they don't always. But always write opinions or dissents. But when they do, it's good to read it, even if you're not like a lawyer, because it really shows where their thinking is on these legal disputes. And that's what they are. They're not policy decisions, they're legal disputes.
I see. And with 4 pending emergency requests, including revisiting TPS and passport sex markings, you highlight how issues keep boomeranging back. So, based on patterns in your analysis, what should we watch for if Roberts grants more administrative stays? Does that indicate the conservative majority's tolerance for executive power on immigration?
So with the emergency docket, it's very rare for them to take a case from the emergency docket and bring it up to the merits docket. But it has already happened under the second Trump administration. You had the universal injunctions case, at the end of the last term, that was something off the emergency docket, which they heard um, off of the emergency docket onto the merits docket. Something you have in this upcoming term is these independent agency heads, which President Trump has fired multiple of them, these different, 3-letter, 4-letter agencies, um, including the FTC. And two of these cases had already come up before the court, before the emergency docket, before the court, I should say. And in both cases, they're like, we're going to let the president fire these people in the interim, not reinstate them while it plays out the lower courts. And if it comes up to us, then if it comes up on appeal, we'll consider taking it up. So he had already granted the court had already granted those two victories for him, victories for now, I should say, interim victories. And on the second one of the justices said he would have actually taken it up now. He would have taken it up for merits arguments now. And the third time it came up, this was over the firing of an FTC commissioner, Rebecca Slaughter. The Justice Department in their petition also said, please seriously take consideration to taking this on the merits docket. And the court actually took the case up for the merits docket. They're going to have full oral arguments for it in December. And this could overturn a 90-year precedent over limiting how a president can fire independent agency heads. Some of the courts already hinted out by granting these emergency petitions. But that's an example of an issue's come back to the court on the emergency docket. It first came to them in May, came again in July, and then it came to them again, I believe it was last month, or it might have been August, in short succession. And when it keeps coming back to them, they feel the need to have to put down a firm opinion, have to give a full merits arguments for these cases so that they can instruct the lower courts, this is the precedent now. This is what you should follow. So if similar issues continue to come up before the emergency docket, the justices might be motivated to take up more cases off the emergency docket, although it is very rare, even though we have seen it already this term.
Okay, so let's zoom out to other Trump-related heavy hitters. So in Louisiana versus Calais, set for re-arguments on October 15th, the DOJ wants to gut the Gingell's framework for race-based districts under the Voting Rights Act. So your article notes Louisiana's map flip from 5-1 to 4-2 after lawsuits. So how did you unpack the irony of Section 2 being weaponized for politics over discrimination? And did interviewing DOJ sources reveal why they're pushing to overturn the 1986 precedent now?
So this has been a constant frustration, especially for several of the southern states like Louisiana, which is a party in this case, where under the Voting Rights Act and under the Supreme Court's ruling, which set up the framework for these challenges in Gingell's, you have lawsuits over the lack of a minority majority district where a minority that makes up enough of a state's population can elect leaders for themselves. This is something that's in the Voting Rights Act. And it's been a frustration because you'll have these lawsuits whenever redistricting comes around every 10 years, especially in southern states where they're like, you need to make another minority majority district. And sometimes it doesn't go with the compactness and everything that you look at when you're making a district, a congressional district. And so this was the second time that Louisiana's been in court over their congressional maps that they made based off the 2020 census, mind you, those maps first started getting used in 2022. They had made one minority majority district, and then the courts had said you need to make a second one. So Louisiana made a second one, and then they got sued again, saying this is unconstitutional race-based gerrymandering. And so before the court, they heard arguments in March, and then they kind of surprisingly punted on it at the end of June and said, we're going to hear re-arguments for this in October. And what this really centers at is if the creation of that second minority majority district violates the 14th or 15th Amendments. So it could really gut the Gingell's holding if the Supreme Court rules that way. And what it could end up doing is getting rid of a lot of these minority majority districts that were made and gerrymandered in this way. And so that could really shake up. There's kind of been a mid-decade redistricting cycle already, and that could really shake it up even more if these southern states now are able to get rid of some of these court-ordered districts.
And for the big picture, what Trump cases should viewers flag this October? And to inform our audience on judicial method, how do you predict leanings like Barrett questioning textualism and tariffs, or the liberals dissenting on agency firings? Any entertaining anecdotes from your beat on how these emergency dockets keep justices on their toes?
So it's hard to, it could be treacherous to try to predict how the justices are going to side. You could kind of try to get an idea of like they're very skeptical of this based on their oral arguments, but they can totally surprise you once the decision drops. And so, in that sense, it's hard to predict, and I try to not make any sort of prediction on how something's going to go. They could be very skeptical on one side and then hand them a 9-0 victory when the decision comes down. But with the Trump cases, the tariffs in November, most certainly that's a very hot button issue. And in December, this Slaughter versus Trump case, the FTC firing, that could really expand presidential power, something the court has been hinting at. And it really could do that. Another case which could be bubbling up, the Justice Department has asked the court to look at this case, is having to do with President Trump's birthright citizenship order, where it clarifies or redefines birthright citizenship. The court kind of informally had that case up last term, but it was about universal injunctions. They didn't even touch the merits of the birthright citizenship order, but they could hear it this term. That would certainly be a blockbuster case if the court decides to take it up. Now, the court doesn't have to take up any case if they don't want to. So it's up in the air if they will decide to hear the case, and if they decide to hear it this term, it could even get pushed to the next term. But that's certainly one to watch on the horizon.
I see. Well, Jack, your insights have given us a clearer view of the court's term and the gritty work of reporting it. So thanks so much for sharing how you gather these stories from briefs to interviews, and it really demystifies the process. We look forward to your future reporting.
Thank you so much.
Well, thank you so much for watching Deep Dive. Please visit our website for more of these investigations, and feel free to send us your questions or story ideas. We hope to see you back here next week.